I'm Scott Lachlan. This is the Data Chronicles, and here are your data points. Today, we are discussing scraping, the practice of collecting and harvesting large amounts of content from websites on the internet to use that data for other purposes. For example, an organization may simply deploy crawlers or other freely available tools to copy text, images, and other content that is on websites. This practice, which has long been used since the early stages of the internet, has found new prominence and, frankly, new scrutiny with the innovations in AI. Artificial intelligence and large language models need large quantities of data to train and to learn, and there is no place easier to pull that information than websites that make digital content available for free in an easily accessible manner. And that makes sense, right? Because all information on the internet is accurate and complete and been collected appropriately. So no issues there, right? If only that were true. Things would be so much easier. But alas, there are so many issues. Everything from IP and data protection, product liability, accuracy, others. I mean, the list goes on and on. And to discuss that and really to kind of suss out some of those issues with respect to data protection and IP, I have invited a few of my colleagues to sort through the current world of AI and data scraping. With me is Eduardo Eustron, who is my co-lead of the privacy practice at Hogan, Lauren Curry, a counsel in our IP practice, Alyssa Golay, a senior associate in our privacy group. Everyone, welcome to the podcast. Alyssa, maybe I can start the conversation with you. Can you just give us a sense and an overview of what web scraping is, how organizations do it, and what uses that information could have?
Sure, Scott. So, web scraping generally involves obtaining specific types of information from online sources. So, companies will use technology to extract or parse, in other words, scrape data from the internet and convert it into a more accessible format, oftentimes a searchable database. Now, this is somewhat distinct, or some companies do draw a distinction between web scraping activities, which involves the actual collection of specific types of data, from web crawling, which is oftentimes kind of synonymous with what happens for search engines, right? Where you're pulling general information about what's happening on the web using software tools to explore the web and create an index of sorts that can let users know, or the collector know, what web pages are as a whole, and kind of use them for, again, those types of indexing purposes.
So, in other words, the crawlers for a search engine was to identify where content is, but not necessarily pull a copy of all of that content. Whereas the scraping would actually pull and copy of all of the data, the text, wherever the other content that appears on that site, keep a copy of that and use it for their own purposes.
That's right, Scott. Collecting the kind of the discrete pieces of information that are contained within that site, potentially converting it into a different format or something that's a bit more usable for the companies themselves. And that's where we're seeing a lot more of the attention here, where companies have gone through, scraped that data. It oftentimes includes personal information or IP protected information, and then they use that data to then train AI models or for their own purposes.
So I will get into the legal issues with doing that in a moment, but maybe you can just talk through why that is needed and how this data is actually used, especially in connection with the development and refinement of AI technologies.
As you noted in the intro, Scott, AI technologies require vast amounts of data for training purposes. So companies who are developing new models or training and refining it need a wide variety of different types of text or images to train their models. And there's kind of no better place than the open internet, right? Where you've got a wide range of individuals, users, companies who've posted, audio, visual, textual content in different languages about different subjects in different tones. And And so the internet has provided a wealth of resources and material that can then be fed into these models. You can adjust and filter the types of content to then adjust and fine tune a particular model. And so far, as you noted before, this data has been kind of freely or at least widely available to companies. And so it has been fairly easy for them to go out and get access to this without having to, go through lengthy negotiations or spend a bunch of money to purchase specific data sets. And so, as you also noted, there's risks with that because, this isn't necessarily a curated data set in all contexts. Companies do need to take some steps to make sure they're abiding by terms of use or other technical controls that may be on these websites, or being thoughtful about the actual content that they are kind of scooping up as part of these web scraping activities.
Yeah. I mean, and I think that those legal issues are many, and maybe we can just first start talking a little bit about it from a data protection perspective, from a privacy perspective. Eduardo, I'm interested in your perspective, given where you sit at the forefront of AI globally. Can you give us a sense of where you see the privacy data protection issues coming up with web scraping and how you see those starting to come into focus as they're being used in connection with artificial intelligence?
Thanks, Scott. Absolutely. Well, I guess no one will be surprised to know that over the past year or so, the level of regulatory scrutiny on anything to do with AI development has been huge. And of course, as part of that scrutiny, what regulators have been looking at is where data was coming from. And as Alisa is beautifully explaining, in order to develop AI models, you need a lot of data, which exists all over the internet. A lot of that data will include personal data. And it is obvious that the process of training a model will in itself ingest all this personal data. You can debate whether those developing a model are interested at all in the quality of that personal data or in identifying an individual. And we could argue that that data is entirely incidental to the actual purpose of building the model. But because it's personal data nonetheless, it attracts all the privacy and data protection issues that the use and the processing of personal data attract. So, for example, we've seen regulators being very focused on understanding the legal basis on which AI developers were relying on when scraping data or when relying on third parties to get that data scraped on their behalf, and on what basis, given that at least in Europe and in many other countries around the world, you need to fit within one of those lawful grounds, you can rely, given that obviously no one is effectively consenting to this because the data is there, on what other legal basis you can rely. Another obvious one is the issue of transparency. How do we know, or how are we made aware of the fact that all this data that exists around us on the internet is actually being scraped by someone at one particular moment in time, being fed to the process of developing AI and training algorithms? So the transparency piece is something that regulators are struggling with, and so is data minimization. If you think about data minimization, which is, as the word suggests, about using relevant data that is essentially as little as possible when you are essentially scraping the whole of the internet or most of the internet, that seems at odds. So these kind of basic data protection issues are at the very core of what data scraping is about. But the other thing I would say is that the emphasis of that regulatory scrutiny has not been just on those who are undertaking data scraping activities, but also on those who publish information, a lot of personal data on their websites, and let the third parties scrape that information. So all of that is to say that this is a very active area in relation to privacy and data protection.
So many questions there that are coming up in my mind, but just taking a step back, if I'm thinking about how data is being ingested in order to train an AI algorithm, that information may be personal information when I first obtained it. And I may use that information to learn from it and to be able to gain the insights and to be able to generate the product. but the output of those models oftentimes have no connection to a specific individual. And I think many clients ask, well, it says, well, what is the harm? What is the issue if I'm just taking information in, but I am not really disadvantaging any individual through the output because that is not associated with any specific identifier after the fact? Is that not how the regulators around the world are seeing it?
Well, as a lawyer, I would argue that the point you just raised is essential because when you look at it from the point of view of the legal basis, for example, I was referring to, again, amongst our educated and learned audience here, they will all be thinking, okay, well, I know what's the legal basis here. Is obviously legitimate interest because it's in the legitimate interest of whoever is developing this model to collect this data and use it in this way. But of course, that legitimate interest, that balancing exercise of the two types of legitimate interest relies very heavily on the impact on the privacy of individuals. And therefore, the point you were raising about, okay, where is the harm? There is no aim whatsoever to focus on this having an impact on any given individual. We're not monetizing the data. There is no real privacy intrusion. So that's a very important argument to be made in that balancing exercise. But of course, the counter argument there is that, well, you say there is no harm, but if all the data is interpreted in the same way, and that ends up causing some algorithmic bias, for example, that could have an impact on individuals. So I think it is one of those issues that you need to make sure you think ahead about the potential impact, was understanding and applying a degree of common sense, I would say, to understanding the fact that the purpose of training a model has normally very little to do with targeting individuals for any particular reason.
So I think, Eduardo, maybe my follow-up question is the issue here really around, is it only personal data that we're concerned about? And, I think one of the challenges there, and interested in your thoughts on it, is because the way the European setup is that it's not always so clear how to separate the personal data from the non-personal data.
Absolutely. And privacy regulator is going to be focused on the personal data side of things. Personal data itself is not an easy thing to define because when you are talking about personal data, which is information that relates to an identified or identifiable individual, are you really trying to or intending to identify anyone whatsoever when all you are trying to do is to understand the difference between information that is about any individual or what amounts to a name or what amounts to an email address or what may amount to some kind of biographical information as opposed to information that doesn't fit within that categorization. But when you are not intending to identify individuals, because the only purpose, again, is to train a model to speak a language, then one could probably make the case that it may not even be personal data. But assuming that there is, you will have a large amount, or maybe it's a small proportion in the whole scheme of things, but a large amount of personal data. But of course, the non-personal data will be subject to other different obligations.
Alyssa, interested in your perspective on this next before we turn to IP questions. So Eduardo kind of gave the perspective globally about where these challenges are arising, and especially in Europe and in the UK. Interested in your perspective on where the US data protection landscape looks like right now and how these issues are being focused on by US regulators and US legislators.
In the US, we're seeing a similar interest from regulators who are focused on data protection issues and privacy. So the FTC has been very active in this space, and they have, a dual mandate of both consumer protection and competition. And so that's kind of, outside of our Data Chronicles kind of lane, they are looking at it from an anti-competitive perspective as well, and have kind of noted that in guidance. And I believe there may have been regulators in the EU who similarly are looking at it through a privacy and competition competition lens. But it's also being looked at the state level. And so where we're seeing it come up is in various state legislative proposals or amendments to existing data protection laws. We've seen it come up primarily in the transparency piece that Eduardo has spoken about, specifically when the data is being used to train models that will then provide for automated decision makings that may have legal significance. A fortunate kind of out we have in the US is that oftentimes there's an exception to the definition of personal data for publicly available information. And so that's where we've seen companies kind of push forward that argument and lean on, right? While there may be personal information included in the web scrape data, that data was also kind of and oftentimes knowingly and intentionally put forward kind of into this public platform by individuals. And at least from a US perspective, under some of these state laws, you're able to kind of, I don't want to say avoid, but at least mitigate the risk, right, of having to be quite as transparent with some of the very prescriptive requirements that are in many of the state laws that we're seeing come out.
Right. And my guess is that it's probably too early to answer this question, but at some point we're going to need to dive into what the definition is of publicly available, right? So if you think of, okay, there is information that appears in a tax record for, how much people pay for their property tax, and that's something that anybody can gather by going to a particular county site, maybe that's one thing. But what happens if the data was only accessible behind a wall? Or what happens if I had an individual had put up on Facebook, but had privacy settings in place so that the information was only accessible to friends and to family members and to other people that were connected? Is there any difference? Or is the fact that I just put it up on the internet at all, does that constitute publicly available? Or if I use a generally available commercial email setup where that is using bots and different types of training to look through my email to then train its algorithms, is that publicly available? My guess is that a lot of those questions are really going to become the forefront of this conversation in the US at least.
That's exactly right, Scott. And I think companies are going to see that the risk of their web scraping activities really varies depending on the type of data that's being collected and is involved in this. As you noted, right, there's a big difference between your name and potentially some sensitive information or health information that may have gotten out because you posted on a health forum related to a particular condition. We're also going to see variation based on the sources from which the data was collected. So, public tax filing versus, an intimate Facebook group or the like. And then the method of crawling, whether it's, someone manually going through looking at it versus deploying a bunch of bots to repeatedly scrape, in a manner that might disrupt services for a site, for example. And then we haven't quite talked as much about all the different purposes for the activities. But right, if you're doing more of a search index or training a model for a more beneficial purpose versus training a model that's going to target and explicitly market to people based off of personal information, that's likely going to be different to regulators. And then since we've got Eduardo, our global expert, I think the location of the activity itself, right, is going to vary as well, whether you're collecting data about data subjects in different locations or websites that are being hosted in different countries or conducting your actual web scraping activities in different jurisdictions.
I want to come back to each of you as we start thinking about, well, in light of all of the issues that you've raised, how do we protect ourselves, or how do we, work with this paradigm to both be on the scraping side if we're engaged in that type of activity, and also on the defensive side if we have, a site that we've made available to the public? How do we protect that information? So let's come back to that question after we talk a little bit about what the IP considerations look like for web scraping. Maybe Lauren, you can give a kind of quick overview of where you see those key pain points from an IP perspective.
Happy to, Scott. So, like in the privacy space, scraping has been an issue that's been litigated in IP for at least a decade now. Many may be familiar with the LinkedIn IQ line of cases, which established a landscape generally favorable to scrapers in the IP space, and which has been more or less solidified through the case law since, including most recently through the Meta v. Bright Data decision, which issued out of the Northern District of California just about 3 weeks ago now. Where those cases have tended to come out has been, again, generally favorable to scrapers, creating a distinction between scraping, which defeats automated scraping technologies, like CAPTCHA, for example, which is permissible, versus piercing privacy walls, password-protected barriers, paywalls, which generally is not. More recently, the law has also looked at the applicability of terms of use to web scraping for purposes of the availability of IP, but also contract and license related claims. And we saw that take a focus in the recent Bright Data decision. Now, as generative AI has come to the forefront of IP over the past year, with over a dozen lawsuits filed now in that span of time alone and counting, we're seeing the issues again take center stage in IP, but this time largely in the copyright space. And where we're seeing those come up, Scott, has been with respect to the Digital Millennium Copyright Act, the DMCA, and then also Copyright Act claims more generally.
So is it then the case, Lauren, at least in the way the current law is set up, is that if I don't have a paywall in place and I'm engaged in web scraping, is that going to be a lawful thing to do from an IP perspective, or is that still a gray area in the way that the US system works?
It's very much a gray area. And the shades of gray are different under both the Copyright Act and DMCA. So the Copyright Act, especially with the recent line of cases that have been filed in the area of generative AI specifically, raises the undecided question of whether this sort of scraping is fair use under copyright law. And that, we think, is going to be the big decision, hopefully, of 2024 or maybe early 2025, which is going to sort of resolve that grayness a bit under the Copyright Act. The DMCA actually is a bit more black and white. It's interesting because the Copyright Act claims have really taken focus because of this really interesting question around fair use and the debate that surrounds it. The DMCA claims have two different potential prongs, which are much clearer in many ways than the Copyright Act in questions of fair use. So the DMCA claims that we're seeing either take the form of claims relating to the circumvention of technological measures designed to control access to copyrighted works, and those are the paywalls and password-protected sites that we were just discussing. And then the second prong or possibility under the DMCA are claims relating to the alteration or removal of copyright management information. So when we're talking about the circumvention of technological measures, either you've circumvented them or you haven't. Either they're a technological measure that is okay to circumvent under the current line of cases, including HiQ and Bright Data, and those would be CAPTCHA, for example, or they're not, and those are the password-protected sites. Alteration or removal of copyright management information, likewise, it's really a yes or no question. When we talk about copyright management information, just for a bit of background, we're talking largely about things like copyright notices, copyright watermarks, even metadata associated with images or files or text that identify the copyright owner, dates, for example. And so when in the process of scraping, that copyright management information is either removed so that it's no longer associated with the file or altered, you have a DMCA claim. And so while the questions there aren't as nuanced or interesting as the fair use ones that we're seeing actively litigated now, these DMCA claims have been asserted almost universally in the pending litigations that we're seeing in the AI space. And we do expect that they're going to take center stage at some point, likely after the fair use questions are resolved, including because of the statutory damages and exposure that's associated with them.
Yeah, I mean, I'm interested in that point and the point that you made earlier around, where are we going to expect this clarity to come from? Reminded, I enjoy usually speaking with legislators around, the issues around AI and how they're thinking about it. And one conversation I was having this week with a federal legislator was, didn't see the need to do anything with respect to IP and AI, because that's why we have courts. We have existing IP laws that will apply to AI just like it applies to every other type of conduct and technology. So interested, Lauren, if this is something where we're not expecting to see congressional action, where is this where is the certainty going to come from, both from the courts and then also from the Copyright Office?
Sure. So to the extent that there is going to be certainty, and I'll caveat it with that because fair use is always a very fact-intensive inquiry looking at the nature of the use, whether the use is transformative, whether the use is commercial. It's going to be, I think, a question that has to be decided on a case-by-case basis. But to the extent a framework does get laid out, and we expect it will, we expect that to come from the courts and the line of cases that is currently pending in the AI and IP space. So hopefully we'll see some decisions start to roll out towards the end of this year or early 2025. Those cases are all still largely in their early stages, but we do expect to see some movement shortly. Now, fair use, which has been at the forefront of those cases to date, doesn't apply to DMCA claims. There's no fair use defense under the DMCA. So that clarity, in a sense, is already there. And that's one of the reasons we think those claims are so important, and why we're seeing them asserted in all of these different cases, but also why it's very important for scrapers to pay attention to them, because there is much less ambiguity there. There is much less room for defense or argument if you alter or remove copyright management information or circumvent technology that you're not permitted to do in the context of scraping.
Yeah, fascinating. So interested in kind of how organizations try to protect their IP now that when they post this information, including kind of how organizations who are engaged in scraping try to prevent themselves from being subject to these types of claims. Let's come back to that question and first talk about it from a privacy perspective. And so, Eduardo, I promised you the question of what do we do now, right? If either we're a scraper or we're trying to prevent unauthorized access to personal information that sits on our site, what are we seeing clients do, and how are we guiding clients to address these concerns?
Well, it's fascinating you raised this particular point because when one looks at what has been published, for example, by regulators, including the statements by some of the data protection authorities around the world, across all continents, the emphasis seems to be on the protections that website operators, for example, need to put in place in order to avoid their data to be scraped. So it's almost like the emphasis is on you need to protect yourself from something horrible that may happen to you, and we'll think about what to do with those that do it. But for now, let us focus on how you protect yourself. And that is a message that we are hearing from regulators as well. And they approach it almost as a data security issue. If you think about data security in the context of data protection frameworks, it is an obligation to ensure that there are appropriate technical and organizational measures to avoid that data to be misused. So the same mindset is being applied here, where regulators are saying to websites that have all this information, you need to ensure that you bear in mind the threat of data scraping, and then figure out and apply what is appropriate in order to protect the data. And the expectation is that there will be a number of technical controls that will be deployed in order to provide that level of protection. We've seen regulators asking for example, methods to detect those who are scraping. So mechanisms that say, oh, this is not a normal user of our website. This is a user that is trying to interact with us in such a way that they are actually collecting too much information, and they are being asked to, for example, use technology to watermark their data so that it is then easy to see whether that data was taken away or not. But the final thing I would say about this point is that not only seen as a data security point of view, from the point of view of the precautions that you need to take, but also from the point of view of the notification requirements in the event of what we would call in Europe, for example, a personal data breach or a cybersecurity incident, where if data has been taken away and a data scraper has managed to override those technical protections, then the message that website operators are hearing from regulators is, you should treat that as a data security incident and assess whether it is reportable to a regulator, and if so, notify it to the regulator. So it's very much looked at as a data security issue.
I mean, that's fascinating. It's almost like, we've been advising and working with clients for years around trying to protect themselves from adversaries who are looking to gain unauthorized access to their systems and to their data. When those people are trying to take that data and commit identity theft or use it for profitable reasons. And now you're describing a dynamic that we have to have that same type of attention and that same type of controls in place to prevent web scraping. And if we don't, that may result in the same type of data breach liability that we have when it's a traditional threat actor.
Well, that seems to be the message. Of course, not every website is the same, and I think you can think about this as being a message more targeted to those websites whose job is to host and to share personal data in a way like that is what they do, and therefore the onus is on those website operators to distinguish between what could be a let's say healthy and normal use of that data to exchange information and to have access to personal data that may be made available by other users, and what would be seen as an unhealthy use of that information by those who are not necessarily interested in interacting with that website as a user, but that are interested in that information that existed as a source for whatever else they want to do.
Boy, it's fascinating. I mean, Eduardo, you and I are old enough to remember the days where there used to be phone books, which would publish, the names, addresses, and telephone numbers of every person who lived in a particular city or region for anybody to look up if you just walked into a public phone booth. And in order for you not to be listed, you had to pay the telephone company so that your name wouldn't be included. And now we're talking about, what was that, 30 years ago, 20 years ago, and now we're in the world that not only does that information now need to be maintained privately, but if that information is accessible and users had provided that information, organizations like the telephone company would need to have the safeguards in place to prevent people from opening up that phone book.
Indeed. Welcome to the era of privacy by default.
Alyssa, interested in your perspective. So Eduardo was talking a little bit about what organizations who have the data need to do to prevent their data from being scraped. What happens if you're on the other end of the spectrum and you're trying to develop the large language model? What do you do to try to protect against some of these data protection risks in connection with your scraping or collection of that data?
Thanks, Scott. So yeah, if you are the company that is conducting the web scraping activities yourself, so Eduardo, as you noted, focused on the companies that have vast quantities of personal data out there that is then being scraped, you want to avoid those sites, right? Because your collection of that could be the unauthorized access of large amounts of personal data. So in terms of identifying what sites you're going to scrape, you'll want to avoid those that are known to be aggregators or collectors of large amounts of personal data, since that increases the risk that could be viewed as an unauthorized access to that information, and that you could be subject to some of these greater requirements for personal data once you do collect it and use it as part of your training activities. You'll also want to avoid scraping, the dark web or sites that promote illegal or illicit activities. It's probably not going to be great for your model, right? Would impact safety and other kind of concerns down the road in terms of how your model is designed and what it's doing in the training processes. best to avoid that. If you have the time and resources as well, it'd be good to check the terms of use of those sites to make sure it's not explicitly prohibiting web scraping activities or has additional technical controls that are otherwise saying, hey, don't scrape my website, like the robot.txt and the CAPTCHA controls that Lauren had mentioned. Even though, we've seen some of that being permissible, if we're looking at best practices here, right, one of the best practices to reduce your risk is to avoid those types of websites. You also don't want to create fake profiles or usernames or go through logins or pass paywalls in order to access data where those website owners have taken affirmative steps to try to, limit who has access to that site. As those also reduce your ability to rely on, that data was publicly available or otherwise, intended to be used for these types of activities. And then if you don't have as much time or resources to be quite so thoughtful on the front end, due to the tools that you're using or just kind of general resource limitations, once you've collected that big repository of web scrape data, it's best to kind of go through, filter, clean the data that you received, get rid of any personal data that you don't need or other information that was incidentally collected as part of those activities, so you can kind of reduce the risk of what's actually in the data that you've collected and what will be used as part of your training operations moving forward. And then kind of the final thing that's a best practice is really to maintain a record of what you've collected, right? You want to know what all is in your data repository and at what point you did do these web scraping activities, because your data will become stale or there may become other issues that you need to be aware of and mindful about as you're continuing to train your model.
So takeaway I'm taking from both Alyssa, your comments, and Eduardo's, your comments, is that there's a lot of things to do on the front end in order to try to mitigate your exposure and your risk, and that just scraping at large and any kind of data that you can get your hands on without evaluating where you're getting it from and the issues around the collection of that data is probably not the best course.
Absolutely. And I would emphasize that in addition to what Alyssa has mentioned, you hear it directly from, again, the regulators' mouths, that their expectation is that if you are a data scraper, don't even think about engaging with us or when we engage with you and without having a proper data protection impact assessment in place. Because all those issues I was referring to at the beginning about the legal basis, transparency, data minimization, all of those should have already been considered in some detail via a data protection impact assessment. So then from the point of view of not just the mechanisms that or the practices that you follow, that as Alyssa has mentioned, also from a compliance perspective with privacy laws, this concept of the data protection impact assessment is crucial. And don't just follow my or take my word for it, because if you search for the role of data protection impact assessment in the context of data scraping, you will see, for example, the CNIL having said quite a bit about this.
Yeah, I imagine that's probably not the easiest data protection impact assessment to draft. So, but that's a good call out, Eduardo. Lauren, interested in your perspective, maybe on that same question. What do you do from an IP perspective, either to protect IP assets that you may have on a website, or how do you protect yourself if you're engaged in a scraping activity from an IP claim?
Many parallels, actually, to what Alyssa and Eduardo were mentioning on the privacy side, just through a slightly different IP lens. So if you're the content owner, someone who owns the data that is being scraped or at risk of being scraped, Eduardo mentioned, I believe, watermarking in the privacy context. We're seeing a lot of that from a protection standpoint, not just in terms of watermarking, but also making sure there is metadata associated with your content that identifies you, that includes a copyright notice if the content is copyrighted. We're actually seeing an increase now in explicit prohibitions in metadata. So for example, do not train or not for use by LLMs or generative AI or something along those lines, with the aim of putting scrapers or crawlers on notice that this is not something that they are permitted to take or use. And with the hope that ultimately, if it is used or scraped, that could assist in making out claims for willful infringement on the back end of those. Now, similar to what Alyssa was talking about on the scraping side, if you're the one who is going out and scraping this content, attention and sensitivity to these meta tags and additional metadata that are being implemented by the content owners. So making sure, for example, to the extent that you can, that your model, that your crawler, whatever you're using to scrape, is sensitive to these prohibitions, and that to the extent it comes across these prohibitions, it either doesn't take it or that it's being filed away somewhere else where it's then later disposed of and not used. So a number of parallels to what we're seeing in privacy.
Yeah, well, that's good. I mean, I think many of our clients and contacts would be heartened to hear that they can protect themselves on multiple fronts with some of these controls. And I know we're running short on time, so perhaps I'll just end the conversation with one last question, maybe for each of you or anyone who wants to jump in on it. Clearly, you need to be thoughtful and proactive about how to address these issues going forward. I think a challenge is that, as we started with, is that scraping is not new. There are large quantities of scraped data that already exist and that are already being leveraged. Any best practices, any thoughts on how organizations should see their existing scraped data assets and ways of trying to mitigate risks going forward?
So if I may start with an easy one, the obvious step that we are working with a number of organizations on is the development of internal policies and internal procedures that are not just sort of visible to the legal team, but they are really visible and understood and observed by the technical teams that are engaged in either doing the data scraping or engaging third parties to do it for them. Because ultimately, whatever practices are in place, whether they are very risk averse or whether they are very risk friendly, those need to be communicated internally and followed. So I think having that very pragmatic do's and don'ts type approach to data scraping within organizations is a must do.
Yeah, good point. And Alyssa, you mentioned during your comments around filtering and actually looking back at all data sets to try to perhaps de-identify or remove data of sensitivity.
That's right, Scott. So it's going through, and if you have the data repository already, trying to filter out data that you maybe shouldn't have or is of higher risk to retain. And then to Eduardo's point, right, going through and making sure you do have some sort of documentation of your assessment of why it is that you need to retain that data at all, and kind of what your justification was for collecting and continuing to use that data moving forward.
And then on the IP front, it can be very useful to take an inventory of the general categories of data that you have. Data itself is not protectable as intellectual property, but associated files may be, images may be, text may be, certainly profiles may be. And so it's helpful to understand exactly what you have, what intellectual property issues it may implicate, whether you have licenses or permissions associated with those files, and then really importantly, how you intend to use them, and being thoughtful about how you intend to use them is going to be a big factor in the potential liabilities and risk you face in IP.
So I hear this. Bottom line is, at every stage in the process, whether it's old data, new data, or going forward, how to come up approach us, you have to be thinking about it because the issues are numerous and complex. So with that, perhaps we can leave it there. And my guess is this won't be the final word on the topic. And I'll have to have each of you come back on to talk about developments in this space, because 2024 sounds like it's going to be the year of legal developments with respect to web scraping. With that, I'm Scott Laughlin. This is the Data Chronicles, And those are your data points.